Chairman Schmitt.
Thank you. I suppose to further the analogy that Senator Whitehouse gave of reffing the game, I don't think anybody has a problem on this side of the aisle with a ref calling balls and strikes or calling a foul. The problem is, what if the ref's daughter hired the coach? What if the ref has money on the game? What if people start to question the legitimacy of the ref in the game? We all know what happens. People don't watch it anymore. Vegas takes the game off the board. So it gets to sort of this question of, as I referenced in my opening statement with Hamilton, the reason why it's supposed to be the least dangerous branch is it relies on the other two branches for enforcement. And the courts, the Article 3 branch, should be very well aware that if they lose legitimacy, they're cooked. And that's why we're having the hearing, because people are questioning, how does Judge Boasberg, and I would actually ask you, Professor Blackman, pose this as a question. How in the world does Judge Boasberg get a case when he's not the emergency assignment judge, he's on vacation in the middle of the night? How can that happen?
I don't know, and perhaps even more significant, if you read the transcript of the case, he basically told the plaintiffs to change their case. They brought it one way. He says, no, here, plead it this way. Okay, good. Now I'm going to certify class and issue a ruling and go tell the plaintiffs around. He basically litigated the case on behalf of the parties. This wasn't merely a passive bystander. He was an active participant.
It's a statistic impossibility, and I want to I referenced what had been going on in the Eighth Circuit. 10 of the 11 appellate judges in the Eighth Circuit appointed by Republicans. Amazingly, Judge Kelly ends up on all the politically sensitive cases on a panel. It's not possible, except for the clerks there in that office, or the people that work for the clerk's office, are populated by her former clerks. So these are the kinds of things that this isn't just a new phenomenon. This is a concern about activism on the bench that's existed for a long time. It's just now on steroids. You talked briefly, and I mentioned it too, sort of Rule 23 as a more viable option for this, limiting limiting the orders to the parties, the rulings to the parties before the court as a case in controversy. Those are ways to address this. Are there any other structural suggestions that you have? And I also want to pose this to Professor Elisei as well.
Sure. I think one urgent need is to think about automatic stays. When you have district court judges granting universal injunctions and they don't stay their rulings, there's this frantic race to the Court of Appeals and to the Supreme Court, and the executive branch is not capable of actually changing policy on the fly, and that gives rise to these attempts to contempt proceedings. I would think about if a universal injunction is granted or a nationwide class is granted, stay the ruling for 24 hours, 48 hours, some limited period till he's taken appeal to the appellate court, and don't let the judge just ruled against you decide whether appeals to be taken. I think the automatic stay will go a long way to addressing these issues.
Professor Elisei.
I think beyond Rule 23 and the enforcement of Rule 23, it's important to address the scope of injunctions not just through the non-APA route, but also through the administrative procedure route under Section 706. So I think that to the extent that we're going to really address the problem overall, you can't just address universal injunctions that are done outside of the context of administrative action, but also through the process that the APA sets up for challenging agency action.
Thank you. Professor Blackman, I do want to, you recently wrote an article in May of this year where you state the District of Maryland's standing order, that judge that automatically blocked deportations upon filing a habeas petition without merit review is pretty clearly designed to thwart the Trump administration's immigration policies. Could you explain that?
Yeah, this is unusual. So the District Court of Maryland issued what's called a standing order, which is basically an order that applies in all cases. And it says, by virtue of filing a habeas petition, a grant of stay is automatically issued. The Supreme Court has said there's a four-factor balancing test to decide whether a stay must be granted. This is automatic. Indeed, if you actually read this seriously, it's a permanent handcuff on the president's authority to deport people. The judge actually walked it back about a week ago. They sort of modified it. Maybe the Judicial Conference got wind of this. But I think there's still an attempt to limit the executive power in ways that have not been done before.
And it was issued to the government, I think it was writ large, right? I mean,
Yes.
This is very unusual.
Right. It wasn't notice given in each case. It was by virtue of posting on a website. This rule applies universally. There's actually a rule that says any order must be put on each ECF docket. It can't be done globally.
I think so one of the points of this hearing, the Supreme Court has a case in front of it where it has an opportunity to rein this in. And I think the Chief Justice is very keen to understand the perception of the court. It seems to be a good opportunity, I think, probably for the Supreme Court to finally weigh in here. Thank you. Senator Welch.
Just a couple of points I want to make. Number one, the effort to get universal injunctions has been pursued by litigants, including some of the attorney generals who serve on this committee. I know you did, as attorney general, got several sought several universal injunctions.
Since you referenced the vast censorship enterprise of the Biden administration that a court declared was perhaps the biggest offense to the First Amendment in the history of the country, where there were named parties that were specifically enjoined, you mean that case?
Yeah, I do. My point here is that if there's an opportunity out there for a litigant, whether it's a lawyer trying to get the judge that he or she thinks is going to be the most favorable, or an attorney general trying to get the most relief for something that he or she believes in, they'll do it. So it's up to us if we think that process should be adjusted to change it. But it's not a Republican-Democratic deal. I mean, it's what litigants do. The second thing is, Professor Blackman, you mentioned how some of these universal injunctions inhibit the authority of the executive, right? What's the problem with that? I mean, what's so great about the executive having unlimited authority?
Well, I'll take the Alien Enemies Act in particular. This is a statute that's been around for 200 years. It's been enforced in various times. And historically, it's been a very deferential statute. The courts haven't scrutinized when it should be enforced, and they haven't told plaintiffs to turn around. So I think we're seeing not only aggressive use of the universal injunction, but also intrusions upon the executive authority.
So I get that. And let me just be clear. I disagree with you. And I disagree with the executive invoking what I regard as a very discredited law and using it to deny due process. So I'm on the side of pushing back against executive authority. So I don't see that as a big problem. Professor Shaw, one of the things people here are talking about is the class action. Mm-hmm. And here's my question with it, and I want you to address this. I had a small town law firm, and I'd have people who walk in, and every once in a while, they had a hopeless case that we'd take, and we'd get them relief. And if I had to do that in a 4-person law firm and certify a class action, I couldn't have taken that case. So this so-called remedy of using the class action means that those Vermonters or those folks in Washington State or wherever who go into a lawyer's office to seek relief, and that lawyer's willing to take the case, what are the burdens on that law firm if they have to certify it as a class?
Yeah, I mean, it seems to me that, let's take maybe the birthright citizenship example, arguments that challenges can be maintained against this executive order, but they have to be done using the class action device. I'm not sure if those are being made in good faith. Rule 23 of the Federal Rules of Civil Procedure has relatively demanding requirements. The Supreme Court has ratcheted up those requirements in a series of cases in the 2010s. The plaintiffs have to be similarly situated in terms of their injury and the kinds of relief that they are seeking. And the Solicitor General in the Supreme Court a couple of weeks ago didn't disclaim the likelihood that they would be back before the Supreme Court saying, well, you shouldn't even be able to certify a class with respect to this executive order. So it feels to me like a little bit of a heads we win, tails you lose. You can try a class action and we will marshal different kinds of arguments against you doing that, but it is not as though it is very easy to satisfy the requirements of Rule 23, and I think that shifting from these injunctions to a pure Rule 23-based regime would disadvantage those unable to secure representation, who don't satisfy the requirements of class membership, and would mean no relief from government unlawful conduct.
Yeah, and that's one of the things that's so important, hopefully to all of us, is access to the courts for an everyday person in Missouri or Texas or whatever. So you get some lawyers who are just willing to do it because it's a neighbor, it's a friend, it's a cause they believe in. I want them to be able to act and bring that case to court and not have to go through the incredible expense. On the question of universal injunctions, I mean, are there some suggestions you have or forum shopping that you have that would expedite or address what you perceive to be some legitimate problems that aren't siding with the partisan divide on this question.
Yeah. Thank you for that question, Senator. I do think that single judge divisions, which allow plaintiffs to, with absolute certainty, ensure that they will receive a particular judge when they file in a particular division of a district, are an enormous problem, right? That forum shopping is not exclusive to these single judge divisions, but it is the most serious kind of forum shopping. And I should say, as of, I think right now, none of the orders against the Trump administration have issued from judges who sit in single judge divisions, unlike some of the orders issued against the Biden administration. But I do think that the Judicial Conference has already endorsed a proposal that would essentially eliminate these single judge divisions. I think that's something that we should all be able to get behind.
Thanks. Well, I'd be willing to work with my colleagues on some of these practical questions and practical answers where we strip out whether we agree or disagree with the particular decision that's been made by the court. Thank you. Thank you all.